The topic of this panel is called Outstanding Legal Issues in the Open Internet Debate. And boy, there are a lot of them. So let me introduce, I guess, from my left to right, my good friend Tom Navin. In fact, I got a notice on my smartphone today that Tom and I are celebrating 3 years as Facebook friends today. So I am so excited. Angela Giancarlo, our friend, John Nuechterlein, and my former boss, Chris Wright. These guys are some of the best in town, and I'm really looking forward to this. So there are lots of legal strands to the open internet debate. And I was thinking about how to organize the panel. So I think probably the best way to start is chronologically, and to start before we get to the draft Restoring Internet Freedom Order to the pending petitions for cert of the U.S. Telecom case. So as we know, the U.S. Telecom came out, I guess, about a year and a half ago. It got a petition for an en banc rehearing. That was denied. It is now before. There's been several people filed petitions for cert. I think the FCC has still yet to file their brief. I was on their webpage, so it hasn't been filed yet. So I guess the big question to the panel is, what are the odds of the Supreme Court, with the FCC now about to go, wait a minute, we're changing our mind again, that the Supreme Court will take cert of U.S. Telecom? So let's start with Chris.
Really, 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 really low. The Supreme Court sits to hear live debates, and to the extent the last order was about Title II regulation, and the next order is going to disclaim Title II regulation, it's hard to understand why the Supreme Court would want to, review the prior order. I know the cert petitions have been drafted to try to present First Amendment issues and other issues, but let's face it, the big story in the prior order was Title II regulation. And, as of later this week, that's going away, right?
John?
Well, I suppose I agree that the Supreme Court is unlikely to grant cert and have plenary review of the case. There's a separate question about whether there will be additional briefing on what to do about the D.C. Circuit's opinion, given arguments that the most recent FCC order moots that opinion. There's a Munsing-Ware doctrine that in some circumstances will cause a higher court to vacate as moot a lower court's opinion. And so we might see some briefing on that issue.
Angela?
Yeah. First of all, thank you, Larry, for having me. And I'm not speaking on behalf of any of our friends.
Oh yeah, I'm gonna. Yeah, me neither.
Me neither.
You're on the lawyers panel when you hear the disclosures. Okay, disclaimers. Excuse me.
Look, I defer to the Supreme Court and appellate practitioners here, but I wouldn't imagine that they would want to go near this because of inefficiency. They'd probably rather wait for the next appeal.
Tom?
Yeah, there's little to add to that. I think U.S. Telecom flagged that they intended to file a supplemental brief on this exact point if the FCC were to act in a way that displaces the Title II order, which we all anticipate that they will do shortly.
All right. Well, then just a quick question to John, who's our resident, and also to Chris. I was at a meeting the other day, and somebody said that the Supreme Court might do what's called a GVR petition, which I had never heard of. This is very arcane, but apparently GVR stands for grant cert, vacate the decision, and reverse and remand. So both to John and to Chris, is that a possibility? I also heard they might hold the case in abeyance to whenever the Restoring Internet Freedom Order gets appealed, and eventually that. I mean, any of those two possibilities are probably not.
Both seem unlikely to me. GVRs are usually done when the Supreme Court decides a related question.
Okay.
And says, D.C. Circuit or 8th Circuit, go reconsider the case in light of that. And holding a case in abeyance for litigation that, won't be decided for a couple of years is certainly not usual.
Yeah, I think what we'd be looking at here is not so much a GVR as the potential for a GV without the R. In other words, grant and vacate as moot would be one potential route the Supreme Court could take. That wouldn't require a remand to the DC Circuit.
So just to expand on that, so you wouldn't, they would just say the whole decision is moot as if it never existed because the FCC did this? I mean, what grounds would they do that on? Wouldn't that be ruling on the merits?
So the dispute that was presented to the DC Circuit by hypothesis here, and we're all assuming that the FCC does something now to eliminate that dispute.
Right.
That dispute then becomes moot by virtue of the new FCC order. And there's an established body of law for what you do about lower court opinions pending review when a case becomes moot. And it's complicated.
Well, that's why we had you to explain. Okay. So, all right. So let's now say that, for the sake of argument, that cert will be denied, but U.S. Telecom will still be on the books, hypothetically, and we'll get to that in a minute. All right. So with the threshold question now passed, let's all talk about the sustainability of the draft restoring internet freedom order as we've sort of seen it. And this is great because it's a draft order. We can just play armchair quarterback all we like. But it's interesting. So, I mean, I think it's safe to assume that the chairman and probably Commissioner Carr, who was the chairman's legal advisor and former general counsel, have probably been writing this order somehow in the back of their minds since 2015. So they kind of know what they want to say and they thought about this a lot. But I'd like to know what the panelists have to say about this. So there's a whole bunch of, I would say, sort of major questions that would come up in the order. So I guess the first question is, and I'll start this with Tom. The big kahuna question is the ability to change direction again. I mean, we're all familiar with the standard that, an agency is free to reverse course so long as it, presents a reasoned explanation for doing so. Even U.S. Telecom, the D.C. Circuit said that, the 96 Act's definitions were, quote, not intended to freeze in place the Commission's existing classification of various services. Still, okay, if it's a really short time, and this is just this back and forth merry-go-round, the FCC in the order is going to have to show that either this was actually Howard Shalansky used this line, I heard him say, that the agency either sort of underestimated the costs or overstated the benefits to justify, as part of its just change in policy. So, Tom, do you think the FCC did a good job? Will the DC Circuit, if it reviews this, buy it?
So this seems to be a unique time in Washington when there is bipartisan support for restraining executive branch overreach. Chairman Pai's proposal for restoring internet freedom should be celebrated for its adherence to the law as it existed 2 years ago. So since then, we've had a temporary, detour and frolic with regard to imposing utility regulation on a dynamic industry, the internet. And I think that their order is helped by the fact that there's so much precedent in support of their position. So they rest not only on economic analysis and new analysis about the disincentive effect on investment, and I think that they cite some figures that the Phoenix Center came up with regard to how much investment was deterred. It doesn't strike me as a complicated argument to understand that the more regulation you impose on the ability of providers to recover their investment on these very expensive networks, that they're going to build less of them. I think that's in part, why there was bipartisan consensus from the late 90s through 2015 to regulate internet access as information service. So your change circumstances question or this change in direction, they rely, not just on new economic evidence, but they also rely on their own interpretation of the statute, which is more consistent with the precedent. And I think that they would argue that that alone should be enough to get past arbitrary and capricious review, because both the D.C. Circuit and the Supreme Court seem to think that the statute is sufficiently ambiguous for the FCC to have some latitude in how they interpret it. So I think that they've done a tremendous job, and they had the good fortune of 30 years of precedent to go back to and cite to support their position.
Well, I can't add too much to what Tom has had to say, but my observation with the order is also I like the way it's written. It's dispassionate, again. One of the things that troubled me very much, just as a former FCC staffer, was the immediate past. So many of the decisions were written not dispassionately. They were written in a very different way. So I like the fact...
Passionate way.
A passionate way, that's good. So I like the way this order is very careful and dispassionate and comprehensive. I think that, just as Tom laid out, they've covered all of the bases, and I find it compelling in a sense of the most immediate order was an outlier, and this, we are really carrying on the trajectory from, again, back from the Clinton administration.
John? Or Chris, go ahead.
Pass the football to
Well, I'll say that one thing that the draft order definitely does is show that the agency really, really, really believes that the last order was wrong. That's one of the prime prerequisites for changing direction, and I thought they were rather passionate about that.
Yeah, I do sort of miss the days of, like the pricing flexibility order in 1999. To the ordinary person, it's just boring to read, but that's actually what agencies should do. They should just address the hard issues on the merits and leave the press releases for other people.
So
And I think there's less of that in this order than there was in the Title II order. The Title II order was like a really long press release.
But if it goes back to the D.C. Circuit, I remember watching the oral argument of the U.S. Telecom, and I remember, I think it was Judge Tatel looking at John Sallet, and he goes, "So why'd you change your mind? It certainly wasn't change of circumstances." Is the court going to just, do we set up this sort of never-ending merry-go-round of agency discretion? We were joking as we were starting to think that maybe just at the turn of depending on what party takes election, it automatically just, this rule just kicks in, reclassification comes in with D's, reclassification goes away with R's.
Yeah, so there's an obvious solution to that in a democratic system, which is legislation. And I think there's a good case for legislation here. Unfortunately, I think that there are political dynamics that make legislation difficult because people derive too much political benefit from there being this blazing dispute out there. But at some point, hopefully, Congress will step in.
So can I just say on that score, if internet access is not information service, our job as lawyers becomes very, very difficult in trying to draw any classification line.
Right.
So that's the way it had been for a long period of time. So you could say, well, if you're providing internet access, you're an information service provider, or if it's something that involves processing around the internet. So it becomes very, very difficult to try to understand the statutory structure if internet access doesn't implicate information service.
That's an excellent point. Yeah, go ahead.
I was thinking that it reminded me of Admiral Allen's example of where does the jurisdiction from the different agencies start when you're talking about a leak, an oil leak. Under the past order, it was very, very difficult and confusing, quite honestly, by splitting the network into so many different pieces. And I also think that this new paradigm, which the commission will be voting on, is much more consumer-friendly, if nothing else. That was a concern to our office when we were at the FCC, and I think it's on the minds of every civil servant there, is what is our action today going to mean for the consumer? Will the consumer know, to whom to go when he or she has a problem? And I think this makes things much easier.
You just raised an interesting point. Let me just. I remember having this discussion. Maybe it was one of our rooftop policy roundtables. But in the 2015 order, the ripple effects of how do you write this? And so, let me ask you, because Tom, you're one of the best sort of nuts and bolts telecom lawyers out there. With this unreclassification, how does that sort of affect sort of the rest of the landscape? Does it clear things up? Is it things? You just sort of alluded to a moment ago, just all these little things that sort of get touched by this proceeding. You have this classification, but then there are ripples in a pond, so to speak, from the stone being thrown.
So if I were being asked to spend tens of billions of dollars to build out a 5G internet access network that has the potential to replace wireline video, I would sure want to know that the government was not going to be involved in dictating the pricing of that service to consumers.
Okay. Which then brings me to a related topic, preemption, right? Which is another big deal. So my reading of the draft Restoring Internet Freedom Order, the FCC did. I would actually say that was exactly what they did in 2004 in the Pulver Order. They basically said that bias is a Title I service subject to exclusive federal jurisdiction, with the hope, the prayer that we avoid death by 50 cuts, going back to the early VoIP arguments. So I guess my question, I'll start with Chris, is that going to be enough to stop suits? There's a case, I guess it's in the 8th Circuit, I don't know if either one of you two are working on the Minnesota VoIP case. Is being able to declare this is a federal exclusive service subject to exclusive federal jurisdiction going to be able to stop, because there's already been efforts with privacy laws and that sort of stuff.
So let me make clear first that this is not a result that I think is good, but I think there is a really good chance that the FCC will convince a court that it has no jurisdiction and therefore no ability to preempt. The draft order is sort of both contradictory and confusing on this. The primary basis for preemption in the order is Section 230B. But then later on in the order, they say that Section 230B is merely hortatory and doesn't give them any jurisdiction. Frankly, that's probably the better reading of 230B. But so if you have jurisdiction, you can choose not to exercise it and say this is federal policy and usually then preempt. But if you don't have jurisdiction, I don't think you can preempt. And let me add in this connection that the commission tried, of course, it adopts a transparency rule.
Right.
And it finds two bases for jurisdiction to do its transparency rule. And, frankly, it was obviously sitting there. We got to find some provisions that won't allow any sort of major jurisdiction. But they end up with 218 and 257, neither of which apply. 218 is a provision that was added in 1934. It's 2 sentences. Both sentences refer to carriers. That provision is only governs carriers. So if it's an information service, that's irrelevant.
Carriers or any affiliate of a carrier. Pardon? Carriers or any affiliate of a carrier.
Yeah.
Yeah.
Okay. And 257 is sort of even farther afield, because it gives the FCC regulation and then has a parentheses that says, like, under other provisions of this act. It sort of couldn't be more clear that 257 does not give the FCC authority to regulate unless you can point to something else. in the act that gives it. So in its zeal to disclaim jurisdiction, I think there's a very good chance that the jurisdiction it claims won't even support a transparency rule.
You know, it's sort of interesting when you look at some of the FCC's orders in the aughts. There were, let me talk about the Vonage order, for example. Vonage is a VoIP provider, and the FCC has still not decided whether it thinks that the service Vonage provides is a telecommunication service or an information service. But it nonetheless preempted state common carrier regulation of Vonage on the ground that even if Vonage is providing an unregulated information service, there's a strong federal policy in keeping interstate information services exempt from state regulation. And you know, some people wondered, is that really a credible basis for asserting preemption? And it turns out that, at least according to the Eighth Circuit, it is, because the Eighth Circuit upheld the Vonage order and embraced that particular ground. So what I think you'll see, particularly if this comes up in some circuit other than the Eighth Circuit, is Chris's argument for those opposing preemption and some significant reliance on the Vonage experience in the Eighth Circuit's order in that case on the other side.
So VoIP is somewhat different, though, because the FCC has pointed to a whole bunch of other provisions in the Act
That's true.
that authorize the FCC to do various things to
But it didn't,
companies like VoIP, but not the Internet access provider.
and it didn't rely on that point when it preempted, and it didn't say we need to preempt this so the Vonage will grow up to be a better competitor to regulated Title II telephone companies. It just said this is an interstate information service, and we have this categorical opposition to state regulation of that. And you can disagree about that, and you can disagree with whether the Eighth Circuit was right or wrong. But you know, there's at least some precedent supporting the FCC's preemption here.
Right. Well, I hope next year we're not here discussing, you know, California's many regulations concerning internet service providers and all the lawsuits that are going on under California Code 17, whatever it is, but possible.
I'm always looking for good topics. Did you guys comment on that, on the preemption stuff?
Yeah, I would just say that, you know, Chris's point is an interesting one, as is John's. You know, the Act anticipates dual jurisdiction, you know, particularly in the area of Title II. You know, Title I plainly gives the FCC authority over all interstate communications, which I think the argument that internet-related access is interstate communication. The question of whether or not they have to tie it more firmly to another provision to establish the federal preemption, I think, is a close question. So I think that'll be a litigated issue.
Well, Angela, do you have anything?
No, I was just going to say that's kind of the heart of the whole thing, right? And I think Chris's point is very thoughtful. And, you know, the other thing I'll say is it's possible that the order will change between now and the time it's public. Right now, it's a draft. So I'm sure, you know, all of the offices are figuring out how to shore it up or otherwise.
Well, that was actually a great segue into my next question, and the question of how much authority have you actually given up, which is I think a big legal crux of this order. It's not you have authority and I choose not to exercise it, but which is oh, can you hear me now? Okay, which is the consumer protection issues. This is the part where John has to put on his sunglasses and his earmuffs, because we're going to talk about AT&T mobility for one quick second.
Yeah, and just to explain that comment, I was at the FTC when that lawsuit was filed. I'm now at a law firm that does a lot of work for AT&T, and so I'm just not going to touch that one.
Fine enough. All right, so the FCC in the draft order adopts a transparency rule. And it was an absolutely fascinating discussion about the problems with the authority to do so. So they adopt this transparency rule. And I guess the theory is that, and they said, but we're not going to take any other responsibility, and we are now going to return where we were before, back to 2015, and the FTC will be able to look at this under the antitrust laws and under Section 5. And I guess the theory of having a transparency rule was that if you violate the rule, that will then provide the grounds for the FTC to bring an unfair and deceptive practices case. Fine. And Harold Feld has been creating quite a ruckus the last couple of days, saying, well, that's fine, but you have this AT&T mobility case. And for those who are unfamiliar with the AT&T mobility case, just real quick, I'll explain it, Johnson, is that prior to reclassification, the FTC brought a suit against AT&T, an unfair deceptive trade practices case on, I think it was the transparency of their unlimited plans. And AT&T said, no, you can't sue us because we're subject to the FTC is barred from enforcing common carriers. And the FTC says, well, it's not status-based, it's activity-based. And AT&T actually said, no, it's status-based. We're some great person in the sky has said we're perpetually a common carrier on everything we do. And the Ninth Circuit bought it. And so, as Maureen Olhausen said last year here, it's like the logic of that case is that, if I'm a dietary supplement company, I want to do a reverse engineering, reverse merger with the railroad, so now I can be immune from Section 5 enforcement. And sort of that decision goes. So long story short, the Ninth Circuit, the FTC appealed for rehearing en banc to the Ninth Circuit. The Ninth Circuit granted that and said we are vacating the earlier decision. They have vacated, but they have yet to rule on that decision. So the entire FCC theory of consumer protection, the FTC can do it, really has come down to we're waiting on the Ninth Circuit. So Harold has been very adamant. In fact, there was a piece I just got late last night, and they said, well, why don't we wait on this? And the FCC's response is, and I quote, "This is just evidence that supporters of heavy-handed internet regulations are becoming more desperate by the day as their effort to defeat Chairman Pai's plan to restore internet freedom has stalled. The vote will proceed as scheduled on December 14th. I wouldn't call that a legal argument, but this is an interesting point, that let's say the Ninth Circuit goes the other way. Where does this sort of leave it? Is that a vulnerability? So, Tom, I'll start with you on that case. Go ahead.
That's one that I don't. Yeah, I don't. Kind of like John, I don't care to comment on that case. So, given our various representations.
Anybody want to be bold? Angela? Chris? Thank you. Go ahead. Thank you, Chris.
So, the fact that the Ninth Circuit took the case en banc is usually a pretty good sign that the court has doubts about the panel opinion, and with, two federal agencies coming in.
Is your mic on?
Is my mic working? No?
Just use it. Chris, use it.
Sorry. So maybe this problem doesn't arise. But I think there is a problem if an awful lot of the order is predicated on the idea that regulation by the FTC is sufficient. And if the FTC loses the ability to regulate, then, that sort of undercuts the order. Let me say in this regard, too, that one part of the order I don't understand. I understand the first part, where, being regulated by vague standards like, unjust and unreasonable practices and not, discrimination that's not allowable. They present real problems. We know that. But Section 5 makes unfair practices in commerce unlawful. I think I could find, all the things that the prior administration thought ought to be unlawful to be unfair practices if I were at the FTC.
Actually, I think, I can address the, I think without commenting on that case, I can address the Section 5 issue. And Chris is right. There have been criticisms of the FTC Section 5 authority, but let's unpack a little bit what that authority is. There are two prongs. There's unfair methods of competition, which is basically the FTC's antitrust authority. And then there's unfair and deceptive acts and practices, which is its consumer protection authority. And in both cases, there are, there's not just, there's both precedent, longstanding precedent from the FTC that identifies when it will and will not bring an enforcement case. There's also a statutory provision that closely governs how the FTC uses its consumer protection unfairness authority. It's Section 5N of the FTC Act, and it says that before the FTC can act on that authority, it has to show significant consumer harm that consumers couldn't avoid and that isn't outweighed by consumer benefits. And that's actually a really useful cost-benefit analysis of the sort that we didn't see in the Title II order a couple years ago. And so I think there would be greater predictability under a Section 5 regime than there is under the FCC's approach to what was the conduct standard, where they had 7 non-exclusive factors that they would consider on a case-by-case basis. In general, the ISPs were largely at sea in determining what that meant, in part because it was a brand new regime and there really wasn't any precedent to guide anybody.
Right. So, of course, the last order based a lot of its justification on the virtuous cycle, which also passed muster in the D.C. Circuit, and sounds like a sort of cost-benefit analysis to me.
I mean, I disagree with that, but I mean, that's a longer discussion, which we can have.
Let's see how we are on time.
Okay.
Okay, so, all right, next. Are we still having Mike? Mike, where's my line? Let me borrow this for a second. All right. Okay, so moving on, then the next related topic of sort of abrogating jurisdiction, I guess the way to do it, is Section 706. I found it fascinating. We borrowed this. Thank you. Is this better? Okay. So I found it fascinating that the court, the FCC, through a lot of pressure, I know it's sort of political, said, Section 706 is hortatory. But the last time I checked, it's the courts tell the agency what to do, not the other way around. And the D.C. Circuit on multiple occasions said, no, it's not hortatory. It is a source of authority. I think my own view, I did a law review on this a couple of years ago. I think originally Section 06, I argued it was sort of a super ancillary authority because you still had to tie it back to something specific. But I think in U.S. Telecom, the court got so angry that they just went past it and said, now 706 supersedes 201, 202, 203, Section 10, whatever. So, but the question is, a couple of questions here. Assuming this case goes back to the D.C. Circuit, where the agency is making a very strong statement to one judge who has written all 4 of the decisions, is this going to be a problem? Tom, what do you think?
So my recollection is that the D.C. Circuit, again, observed that the commission, I think in earlier orders, had specifically not identified it as the basis of support, and the question of whether or not it provided, any extra authority to the commission was something that the D.C. Circuit was going to defer to the agency on. So it is another flip-flop on an ambiguous, statutory provision, but it's a little amusing to me that a provision has been around as long as 706. With, you can imagine, hundreds of lawyers in Washington studying it, and then, in 2015, it provides an additional source of authority that prior commissions didn't believe that it provided. So when I was there, the thrust of the act and the thrust of 706 was viewed to be a deregulatory thrust. And my recollection is we used it for purposes of carving out in the unbundling order the advanced internet access networks that the carriers built. So that struck me as supportive and sensible to use it as a deregulatory tool, but to use it as a primary tool of regulation seems to be at odds with the whole structure of the Act and how prescriptive Title II is by itself.
So I guess can I
Please.
Okay. So the DC Circuit encountered 706 three times, one, or at least three times. One was initially in the Comcast case involving the BitTorrent incident. And the FCC cited 706 as part of its grab bag of provisions that entitled it to come down on Comcast. And the DC Circuit observed that the FCC had on the books this proposition that 706 is not an independent grant of authority. And so the DC Circuit said, well, as long as you still have that on the books, you can't be invoking it as an independent source of authority. So the FCC went back, and in the Giancarlo era 2010 open internet order, they embraced 706 as the primary basis for their net neutrality rules. And they invoked the virtuous cycle arguments that Chris has mentioned and said that we need these rules in order to promote greater investment, both in broadband and at the edge. I mean, you can think that's a pretty empirically tenuous position to take, but the DC Circuit upheld that in the Verizon decision in 2014. The reason the net neutrality rules were nonetheless struck down was because 706 is subject to limiting principles under Section 351 of the Communications Act, which says that if you're not a telecommunications carrier, you can't be regulated like a telecommunications carrier. That's why in 2015, the FCC flipped from a Title I theory to a Title II theory to justify all the net neutrality rules that it wanted to impose. So Section 706 still remains available to the FCC as a basis for some limited net neutrality rules that don't cross the line into prohibited common carriage treatment of information service providers. But the Commission has now decided that it wants to construe 706 once again as though it's not an independent source of authority. It will need to persuade the DC Circuit that it has reasonable basis for changing its mind on that. I think that the DC Circuit will probably recognize that 706 is ambiguous on this point, and so it'll become your usual APA challenge to the reasonableness of the FCC's decision.
Chris?
Nothing to add to that.
Andrew? I'm sure it wasn't light. All right. Well, let me ask this question. Just sort of about Section 706. I mean, I think that actually there was one case, there was the ad hoc telecommunications case, which was prior to that, which was actually somebody had tried to use Section 10 as forbearance. Section 706 is forbearance. And what was significant about that case, which is what started me on my theory that it was enhanced ancillary jurisdictions, the court said, no, the only exclusive authority you have in 706 lies in Section 10. So again, it was sort of a way of bolstering.
Yeah.
It's like it was like.
Yeah, so the DC Circuit often cites 706 as a basis for upholding FCC decisions under other statutory provisions, but there's a separate question about whether 706 is its own affirmative source of authority.
But then this brings an interesting question. I think if you take away the politics of net neutrality for a moment, the policy, a lot of this, the whole argument of reclassification is that we've been constantly struggling for some sort of legal theory to move forward on. And people, because our dichotomy is Title I or Title II. And Title II doesn't quite let you do what you want to do, but the DC Circuit sort of glossed over that. And Title I has its problems. And it's not just issues of net neutrality, but other, everything from public safety and, where you put a PSAT and universal service. I mean, are we back to the same? I mean, now that we take the policy issues, and yes, the investment killing defenses, but are we back to the same legal problems that we had in 2015 of trying to dance on the head of a pin and going, well, how do I sort of figure out where I've got enough? I mean, are we back to trying to make ancillary jurisdiction arguments? That's kind of, from a legal perspective, we're back to that sort of headache as well. I mean, it's great that, as Tom said earlier, that, you know, with investment, I want to know that you can't set my price terms condition, but we're still back with, well, what exactly is the role that the FCC has if you abrogate that much authority? What do you do? Tom?
So my recollection is in the last DC Circuit case that they sustained the commission's, or I'm sorry, in the Verizon case, they sustained the commission's transparency rules under Section 706 analysis. So, you know, the question I think you're asking is, what are the implications for this order in terms of reinstating the transparency rules?
I mean, just generally, I mean, we're back to, you know, is it Title I service, is it Title II service? How do I, just general telecom law of, we're back to, it's an information service, but yet maybe I might have to do some public safety something. I might have to do tower siting. If it's an information service, you lose all those other things with pole attachments. You know, we're back to that, you know, as more things become information services because we want light touch regulation, how do we, you know, is that problematic in what we all do for a living?
So what I would say is that I think the commission stands on its firmest ground when it regulates consumer disclosure, so which is what the transparency rules effectively do. So I would think that the commission could even anchor those transparency requirements in its Section 1 authority. So, which is, as everyone here knows, is an extremely broad authority because it allows them to reach any interstate communications, interstate or international communication. So, whether or not it has 706 as an additional affirmative grant of authority, I think it seems probable that consumer disclosure requirements, you know, the commission will be, you know, those will be looked upon favorably upon review.
I think there's plenty the FCC can do without having to resort to Section 706. Tom mentioned Title I. I heard thousands of public safety arguments when I was there, and that is exceptionally broad, you know, as an ancillary jurisdiction in any event.
So we'll start to see a greater development of case law, so to speak, under Title I, which was sort of and we'll see where that gets tested in the court, is what you're basically saying?
Yes.
Chris? John?
Well, it's interesting to find out that Title I is so broad, but as I understand Title I, and I'm pretty sure I've got this right, you have to find a hook somewhere in the statute that gives the commission jurisdiction over whatever you're talking about. The commission found 706 to be that hook last time. It's now disclaimed that. It's hit on 218 and 257, which, as I say, don't seem to work. So I'm not sure it's so broad.
I think in the E911 context, we actually just use Title I.
Yes.
I just have a sociological observation to make, which is, I think, Larry, you mentioned what a drag it is for us lawyers to have to like deal with these hard legal questions to keep popping up. Actually,
It's not a drag. I love it.
Yeah,
And your billing rate is fantastic. You can think about that a lot. All right, so here's the final question. As we started the panel, we've come to the conclusion that the Supreme Court likely will not take cert of U.S. Telecom and will likely not
grant plenary review on the merits.
You are so good. Okay. But there's a good chance that U.S. Telecom will still be on the books after this process gets done. I wrote a paper, I guess it was this summer, ironically called U.S. Telecom and its Aftermath. I think U.S. Telecom is one of the most dangerous cases that I've read a while in terms of giving agency discretion. You all can read the paper. It's on our website. And as we know, the first thing that a Democrat administration is going to do is to sort of reclassify and use U.S. Telecom. I mean, U.S. Telecom, among the points that I make is, again, the court has said Section 706 trumps 201 and 202, so therefore Title II has no meaning anymore under the reading of U.S. Telecom. The agency can now set a rate without any form of a tariff, any form of a cost study, any form of a cost methodology. It is just, you will take a price of this. And it's interesting, as I point out in the paper, that the same theory that the FCC used in its open internet order, they tried to use, but then were stopped because of the election, in the special access order, which was, well, here's, here, I'm going to de-tariff you, but I'm still going to impose a price on you. So under the DC Circuit's holding in Orloff, it's like, yes, you're still a Title II carrier and you have the backstop of 201 and 202 and a complaint proceeding in 208. But Orloff says once you de-tariff, you surrender to the market. But yet my reading of U.S. Telecom says that it gave permission to the FCC not to forbear, which is, and even the forbearance standard is bizarre in that case, not forbear to relieve constraints on the regulated, but to relieve constraints on the FCC itself as a regulator. So what do we do about that? I mean, is it a legislative solution? But it's out there. Chris?
Well, we have an ambiguous statute in many ways. Certainly there are some provisions that are less ambiguous than others, but a lot of the key provisions here are admittedly ambiguous. Under Chevron, as it now stands, there's a lot of latitude for any new administration to make changes. So, whether or not these particular ones exceeded that, I'm not going to opine on, and whether or not the next Democratic administration, when it changes position, is going to exceed it, we'll see. But maybe there'll be a change in Chevron.
Let me ask you this question to follow. Would it have made a difference had the actual rules been challenged in U.S. Telecom? I mean, the main argument in U.S. Telecom was the ability to reclassify. So it was a question of the statutory limitation. It was never, implementation of it was never challenged, aside from the general conduct rule. But, the actual implementation of it, would that have made a difference? Because that's still an unresolved question, because the FCC, Wheeler's FCC was like, hey, we can do whatever the hell we want. Because nobody ever challenged what he did. Yeah. Go ahead.
No, I mean, that's very interesting. I mean, no one did challenge that. I think it was invoked.
Our amicus brief was about it.
Right, and not only that, there was a practical example with the investigations into the wireless offerings.
Right.
So, but I guess because those were not resolved formally, there was nothing to appeal.
Right. Tom?
Every time there's a legal action as it relates to these issues, it changes the political dynamic, and the possibility for, legislation is then revisited anew. I mean, the reality is that the tools that Congress provided to the FCC in the 96 Act are only so good, right? Otherwise, we wouldn't be having this debate. If it was very, very easy to determine when something was a telecom service or when it was an information service, you wouldn't have the agency flip-flopping back and forth. It's a complicated determination because the statutory definitions necessarily implicate some functionality that has migrated in the networks to the routers and the switches, and determining what's a computer versus what's routing and switching equipment has become very difficult to parse. So at some point, I mean, it's very hard to know, but every action, changes the political dynamic in the city as it relates to litigation and both legislation. So
Sounds like almost like a Marxist critique. It's like the dialectics of telecom regulation. This is the antithesis, synthesis.
Exactly. Well, looking at the time, I know that John's got a conference call. I really appreciate everybody in this panel. This was excellent. I thank everybody. Hope everybody enjoyed ourselves. I see our award winner and keynote is in the back. So we will now proceed to move to that part of the program. So thank you, everybody. We appreciate it.